So thank you all for braving the cold to join us this evening. On behalf of Jones Day, I'd like to welcome you to what promises to be a stimulating discussion on the impact of Brexit on the fight against economic crime. This event is organised by the Bingham Centre for the Rule of Law, and I'd like to express thanks to Matt Trom of the Bingham Centre for his work in planning this evening's discussion. Jones Day is very proud of its partnership with the Bingham Centre, intended to promote and advance the rule of law around the world. The importance of the rule of law in managing efficient markets, combating corruption, establishing good governance and protecting the most vulnerable members of society around the world is difficult to overstate. The challenges to the rule of law are manifest and profound. The migrant crisis on Europe's southern fringes and in Myanmar is both a symptom of a breakdown in the rule of law in the countries people are fleeing from, and a challenge to the rule of law in the receiving countries. State-sponsored cyber attacks and attempts to influence the results of elections in foreign states undermine the democratic foundations of the rule of law. In the US, a criminal investigation of a sitting president tests the boundaries between executive power and the rule of law. And in Cape Town, as the water runs dry, armed police stand duty at standpipes to maintain order. Here in the UK, we are rightly proud of our history as a nation that upholds and promotes rule of law principles. The reputation of the English legal system for providing a forum for the effective resolution of disputes has been a key factor in establishing London as a global commercial centre. Now our relationship with our European partners is about to change. This will have effects on all areas of life, from food production to atomic research. Here to discuss the impact on the fight against economic crime, we have a distinguished panel of guests. Our moderator this evening is Tricia Howes, CBE. Tricia is a barrister and Vice Chairman of the Royal Maritime Club. She is Vice President of the Bar Association for Commerce, Finance and Industry, a bencher at Gray's Inn, and past President of the UK Criminal Law Association. I first met Tricia in 2004 when she was an Assistant Director at the SFO, and I was a newly appointed Case Controller. The stress of that meeting drove Tricia to join the team of experts who authored the Government Fraud Review, published in 2006. Mike Kennedy, CBE, who joins us.
Yep, he does.
He's a solicitor.
Right on cue.
He worked for many years at the CPS Special Casework Directorate and as Chief Crown Prosecutor for Sussex, before being appointed as the UK's representative to Eurojust in 2001. He served 2 terms as the elected President of Eurojust and led the establishment of Eurojust as the European Union's new unit to improve cross-border collaboration between investigators and prosecutors dealing with transnational crime. He's currently a consultant advising on prosecutorial and criminal justice issues. He's an expert member of the European Commission's advisory panel on EU criminal justice policy, and recently gave evidence to the House of Lords inquiry into the effect of Brexit on extradition to and from the United Kingdom, in particular in relation to the European arrest warrant, about which I'm sure we'll hear more this evening. Professor Valsamis Mitsaligas heads the Department of Law at Queen Mary University, London. From 2001 to 2005, he served as legal advisor to the House of Lords European Union Committee. An expert in the fields of European criminal law, migration, asylum, security and human rights, he has advised governments, EU institutions and think tanks. He's currently serving a 2nd term as a member of the European Commission's expert group on criminal policy. Michael Bowes QC is a barrister specialising in business crime, civil fraud, financial services and economic sanctions. He also sits as a Deputy High Court Judge. His practice has a considerable international element. He advises in respect of US and EU sanctions, acts for overseas regulators, and is instructed in overseas cases as an expert in English law. He's registered to practice in the Dubai International Finance Court and is a trustee of Transparency International. The format is that we'll hear from our speakers. I'm sure there will be interesting and thought-provoking questions, but if I could ask you to hold those until the end, when there'll be time for questions and answers and microphones so that everybody can hear what's being said, that would be very helpful. And of course there will be drinks served afterwards, and we'd be greatly enjoy your company later on once the event's over. through the door, which is now being closed. Thank you very much. Tricia.
Me? Michael?
Sorry, I thought you were going as the moderator.
No, I'm not going to moderate anything at all. We live in exciting times, and I'd much rather hear straight away from the speakers than more rabbiting from the chairman. I'm here to make sure nobody asks awkward questions, and if they do, that they are sidelined very quickly.
Thank you, Tricia. I'm very comforted. Let me just make this work.
Look at it, I think. Possibly. We'll see through.
Good. Good evening, ladies and gentlemen, and thank you very much indeed for the invitation to come to speak this evening. I'm going to talk about what I think the impact on the UK is going to be following Brexit on criminal justice cooperation. And I've got a series of slides. I hope I won't bore you too much with PowerPoint, but I'd like to give you an outline first of all of what I'm going to say in general terms. I'd like to give a little bit of background because I think it's pretty important that those who aren't familiar with criminal justice or criminal law within the European Union understand what the background is and what it is we could potentially lose if we leave the European Union without any sort of arrangements in place to replace what currently exists. So I'll go through where are we now and where does the government want us to be. Do they know where they want us to be? It appears they do. But how are we going to get there? And I'm going to make a few comments on that, and also on potentially how long this all might take, which is pretty important from a security perspective, particularly for those involved in criminal investigation, prosecution, defence work, and security in general. And what might be a possible future outcome, future scenario, comparing that with where we are now. Let me start off with the very basics. As we all know, the four main EU freedoms, the freedom of movement of goods, people, capital and services, but that also led to freedom of movement for criminals as well, and for the way that they move goods and services and capital around the European Union. What was the UK's response to the problems that created? Well, there were a number of responses in terms of the creation of a variety of agencies. Europol, the European Police Office, or Drugs Office as it began. Eurojust, which is a lesser known organisation which I was involved with, which is for prosecutors and investigators to help them collaborate together to better deal with cross-border serious crime. And finally, another European office, the office known as OLAF, which looks and conducts administrative investigations into fraud on the European Union budget. Those are the three. There are many others, there are others particularly, but those three are the ones that you'll tend to hear about in relation to criminal law particularly. There are a range of other instruments that have been created to facilitate collaboration and cooperation. I mentioned but a few of them here. The Schengen Information System, Schengen 1 and Schengen 2, which is a series of databases effectively that provide information about criminals and potential criminal activity. The European Arrest Warrant, which is one of the better known, and in many ways one of the key instruments that has been created by the European Union to arrange for the arrest and return of fugitives. A warrant that is recognised and is in very similar, if not identical format, in all the 27, 28, 29 criminal justice systems within the European Union. There is the more recent European Investigation Order, which is in place, again an instrument that effectively replaces, or seeks to replace, letters of request or commission rogatoire as they used to be known. There's an instrument to create joint investigation teams, teams that are made up of investigators and prosecutors, investigating judges, particularly police officers from this country, investigating criminal groups or activities particularly related to crime types or individual criminal organisations that are dealing with, let's say, trafficking across the European Union, or people, possibly of drugs or of arms. There are other instruments that have been created to facilitate the investigation and prosecution of crime. ECRIS is one useful example. It's known as the Exchange of Criminal Records Information System. It's set up by UK police, based at the Home Office, and it allowed investigators and also judges and courts in any jurisdiction to find out details of the criminal records of anyone who was appearing before them. It's proved to be extremely useful. Aside from setting it up and persuading others across the European Union to set it up, the UK is the 4th largest user. There's another instrument called the Prüm Treaty, which the UK was not part of, but has since geared itself up and has become part of, which allows for the exchange of DNA, which is becoming increasingly useful for investigators, and also fingerprints and vehicle registration systems. More recently, and a little more controversially, an arrangement has been put in place to deal with passenger name records and to exchange those name records of passengers who are travelling within the European Union by passing on details of their names, their passport numbers, and a range of other information about how their tickets were bought prior to them arriving in another country. The UK was at the forefront of this and in fact has by far the most advanced system of passenger name record exchange. Many other countries have rejected it, didn't want to be involved in it. The European Parliament struck down the first suggested law in this area. But the UK, France now, a number of other countries, Spain, Hungary, Sweden, have adopted this and are pushing forward, drawing to a great extent on the UK's, and indeed the USA, but and other former Commonwealth countries, Australia and New Zealand. They are pushing this forward and finding it to be extremely useful and effective. So there is a range of EU responses. There's a range of instruments that have been created under the mutual recognition system, and I won't go into them all now, but it's interesting that as part of the Lisbon Treaty, the UK was given the potential to opt out of justice and home affairs arrangements, and there was a lot of political pressure at this time, about 3 or 4 years ago, to opt out of a range of measures. But in fact, the reality became obvious, and the UK opted back into a lot of these measures, and a lot of the measures that I have just mentioned. It's true to say that I think there were well over 140 measures that were considered, and the ones that we opted, or the UK opted back into in December 2014, were many of the ones that I've just mentioned, and the only ones they didn't opt, or we didn't opt back into, were the measures that in fact were obsolete, had been overtaken by events, and were not really of any great practical use to anyone. So to some extent, the Brexit situation that we find ourselves in now is a repetition, in fact worse, than the situation that we found ourselves in back in 2013. So it's interesting to know we're in the situation where we have looked very extensively, the government and civil servants involved have looked very extensively at what we were committed to, and we decided to opt back into a range of useful measures which we are now currently in, but we're now in a situation where we have to consider, if we do leave the European Union, as the referendum has said we shall, what we can do in terms of regaining any benefits of those instruments if we are outside the European Union, how we can perhaps be part of them in some sort of semi-detached way. The white paper on Brexit made a a number of observations, some of which I put up on the screen, in relation to Brexit. And the clear thrust of these quotations is essentially that the government wants to work with the European Union to preserve security, particularly in the fight against terrorism and organised crime across Europe. And that the government wants to negotiate the best possible deal to ensure that the good practice and the instruments which we are currently part of can continue. Things are changing dramatically all the time, but it's difficult, despite a lot of talk and a lot of political comments, it's difficult to find out exactly what the current position is. There's been a lot of talk of impact studies. I suspect there has been an impact study on security and on justice and home affairs measures. I don't know if anyone else has seen anything. I've certainly not seen anything to give or cast any light on what the impact might be, or what the arrangements might be to minimise and to cancel against the risks that this will bring. In Florence, the famous Florence speech towards the end of last year, the Prime Minister said that there is no pre-existing model of cooperation between EU and external partners which replicates the full scale and depth of collaboration that currently exists between the EU and the UK on security, law enforcement and justice. And it was effectively a commitment to try, so far as possible, to maintain that post-Brexit. Quite how it will happen is going to be quite difficult. One of the problems, and you will of course have heard this from other sources as well obviously, is the European Court of Justice and the role that it plays as an arbiter of disputes about the implementation of not just justice arrangements and justice instruments, but also across the whole range of EU subjects and topics. The government, of course, though, has made this very strong commitment that the UK should not be subject to the rulings of the European Court of Justice. But it plays such a key role in some of the instruments that I've been talking about already. It would be difficult to anticipate how these instruments, or how we can continue to be part of these instruments without the arbitration of the European Court. There have been suggestions there might be alternatives put in place, and that we might not have to follow the European Court of Justice, but could follow the rulings of some sort of arbitration mechanism that might be put in place. There's been talk of something similar to the EFTA arrangements that many of you will probably know about being put in place instead. But nothing is clear, nothing has been said about that. There's been a lot of discussion. There have been a number of parliamentary inquiries on these topics, both by the House of Lords and by the House of Commons. The government has said, though, that they're proposing some form of bold strategic agreement that provides a comprehensive framework that will be able to deal with future security, law enforcement and justice cooperation. Some sort of treaty, and that is the ambition. Quite how it is going to be achieved, particularly within the apparent 2-year transition period, is very difficult to understand or anticipate. There has been a white paper on the Court of Justice of the European Union, and there has been the oft-repeated red line that the government has said we will take control of our own affairs, as those who voted in their millions to leave the EU demanded that we must, and we will bring an end to the jurisdiction of the CJEU in the UK. Now that is very clear. There can be no doubt about that. So where do we go from here? The EU, the CJEU, as I've said, is the final arbiter for many EU instruments, including the European arrest warrant. But it also gives guidance and interpretation and aims for consistent application across those 28 to 30 jurisdictions within the EU. How can we be part of many of these instruments without that clause being there? I don't know is the answer. In terms of the instruments themselves and whether we should continue to be part of them, the Home Secretary said that she agrees with the principle that the warrant is an effective tool, essential for the delivery of effective judgment on criminals. And it's a priority, she said, that we remain part of that arrangement, and indeed she's confident that all EU partners from the other countries want that too. Well, the House of Lords Home Affairs Committee inquiry that has been mentioned already, I gave evidence to it, so did a number of other far more distinguished individuals, professors and lawyers, and it's quite clear that the House of Lords, in conclusion of their report, were very concerned too about how the arrangements are going to be dealt with in the future in respect of the warrant or whatever might replace it. So a number of questions arise, in particular again in relation to the warrant, but although I put warrant in here, it applies to many of the other instruments that I've touched on and indeed haven't touched on. Can we be part of these instruments outside the EU? Equally important, will our partners, our potential partners, the other 27 EU states want to replicate arrangements post-Brexit? Can there be a multilateral agreement between the EU and the UK on the warrant and indeed on the other instruments? Would there have to be 27 bilateral arrangements? Would we, for example, have to go and negotiate with 27 other partners to put in place extradition arrangements individually with those people on the same basis as the warrant, or indeed as on individual bases that they might want to negotiate with us? One of the key advantages of the European arrest warrant was the fact that countries that previously had not agreed to extradite their own nationals to another jurisdiction to face trial had agreed as part of the warrant arrangements to do that. It was very difficult for many countries. There were challenges in the highest courts in their land, the Constitutional Court in Germany. There was a challenge that almost struck down the legislation the Germans had put in place in 2004 because it simply was part of their national ethos that their citizens would not be extradited to another country to face criminal prosecution. Could there be some sort of another alternative arbitration system? Well, it's possible there could be, but it will take a lot of negotiation and a lot of agreement. I suspect it will take quite a time scale to sort something out even in the most basic way. Would we have to fall back on previous conventions? For the warrant, it would be the 1957 Council of Europe Convention, which had its problems. Indeed, many practitioners who've been involved in extradition for some time, going back to the 1980s and 1990s, will know that extraditions to many countries within Europe took often 4, 5, 6 years or even longer. Often in the most straightforward cases. The more complex cases took even longer. One of the advantages of the warrant is that there are deadlines set for the return of fugitives within 90 days, essentially, although this period can be extended in different circumstances. I could talk about the Schengen Information System. There are some interesting parts to this system because although it's been a key part of European Union development, and 22 EU member states are members of the Schengen Information System. There are others who are members of it who are not actually in the EU, so there is precedent for the UK possibly to be part of this. And I think this is a likely solution, probably one of the solutions that can be resolved with, not without difficulty, but probably with the least amount of difficulty. There are a number of non-Schengen member states which I've set out there. They are effectively having Schengen a la carte. The UK and Ireland has access to law enforcement information there. Bulgaria and Romania have access for law enforcement, but Croatia and Cyprus at the moment have no access unless that's changed recently. What about the two main organisations involved in law enforcement, Europol, the European Police Office, and Eurojust? There have been massive improvements in the performance of Europol in the past 10 years. They've got a much improved database, they've got tremendous analytical support for the information that they receive from across the European Union, and it is a model of intelligence-based operational support. In fact, intelligence-based policing, something that has been running in the UK for a long time, is something that has been introduced by the current UK Director of Europol, Rob Wainwright, with considerable success and much appreciation, and it's changed the way that many of the police forces in the European Union operate, particularly in relation to serious crime. There are a range of dynamics within civil law systems that we find difficult, certainly in terms of the names and name tags that we use. For example, judges in France can be investigating judges who will lead police investigations. Prosecutors lead in other jurisdictions, particularly in the Scandinavian countries, for example, and in Germany. But in this country, their equivalent might be a police chief inspector or superintendent who will be leading the investigation. And the collaboration that has developed and the trust and confidence that has developed between these different people with different name badges, although in fact they may have the same powers, that trust and confidence that has developed, glass ceilings have been broken through to allow them to develop contacts so that judges now regularly work with police officers and with prosecutors without any difficulty in, for example, the joint investigation teams that I mentioned earlier. We're going to lose that, or at least we're going to be set aside from that. And I think that Brexit is bound to lead to a change. In Europol, for example, if we leave the European Union and leave Europol, it's likely that I think we will remain in some way part of it, or at least as an observer. But it's unlikely, and indeed it's the same with many of the other organisations within the European Union, it's unlikely that the UK will have any real management influence. It will not be a member of the management board of Europol, for example. So the setting of strategy, the key decisions that are going to be made about focus and about development within organisations like Europol and indeed Eurojust the UK will be missing out on influencing that, and influencing it in a way that might help our own priorities and our own strategies. Will it mean that because judges and prosecutors in the European Union tend to lead investigations and set the pace within their criminal justice systems, will it mean that Eurojust will have more influence in the future than it currently does? It's going to be an interesting question. And
Is
if,
this your last slide?
pardon?
Is this your last slide?
No. Do you want me to go on?
Sure.
I think what we need to think about are the big changes that we will effectively be generating by not being part of these systems. I think that there will be difficulties with the attitudes of other member states. The trust and confidence that I talked about earlier may well disappear. In the past, collaboration and cooperation in the 70s, 80s and 90s relied on the little black book of the individual who was working abroad and who got to know people, who put their telephone numbers, their email addresses or whatever in that little black book, and contacted them if they had an issue. Nowadays things have changed dramatically. There are tables around which sit key players who can contact across the table or across the corridor people with the ability to help them in individual cases. there's going to be a lot of negotiation to try and replicate this sort of situation if we are not part of these organisations. And it's difficult to see how that might end up in practice. We've got some credit with other EU states. As I've mentioned, Europol has had a UK director for the past 5 years. He's about to leave his post at the end of his term of office. The UK has been a big contributor to Europol and has been one of its successes, not just through its director, but through the information that it's supplied. We've been viewed, in fact, because of our common law system, as a sort of half member of the EU justice organisations for some time, despite the fact we've had people like myself who've been involved in leading these organisations, because we don't commit in the same way that, or at least they think we don't commit in the same way. There has been an accommodation for our common law approach, which some find rather irritating. It's going to be quite difficult with that sort of background, negotiating new arrangements over the next 18 months or so. So it's going to be interesting to see how it comes out. One thing I would like to say towards the end about the implications for national security, credit these to Joanna Dawson, who provided a House of Commons briefing on the subject. National security is the responsibility of individual EU member states. It's not part of the framework that I've been talking about. So it's outside that, and it's important to remember that intelligence responsibility through security services is dealt with in a completely different way. And a quick slide at the end to see what we will lose. I think that the UK will probably maintain, although some think otherwise, an observer status at Eurojust and Europol. Some have suggested that we might be able to maintain a seat on the management board at Europol, and that we might be able to influence and have a vote on decisions that they make about strategy and future management and business plans and so on. I doubt that very much. I think we will be invited as an observer. They already have observers from the US and many other countries at Europol, and 3 or 4 observers at Eurojust. Schengen Information System, I think that's quite possible. European arrest warrant, possible that European Court of Justice issues. Investigation order, I think that's unlikely. Joint investigation teams, yes, I think that's possible, but we won't have the benefits. The EU currently funds those joint investigation teams and pays for a lot of the travel and accommodation expenses of police officers and others who are involved in these quite complex teams. We'd have to pay our own way there. It's possible we could be involved in ECRIS, Van Proom, passenger name records. I think we're going to keep going with anyway. Whether others are with us on that, I don't know, and it perhaps matter less than some of those other instruments I've mentioned. But what I've sketched out there very quickly is something that I think will lead you hopefully on to the conclusion. This is a series of negotiations to sort this out, which is going to be lengthy and it's going to be complex. It won't be sorted out, I suspect, within 18 months. And so it's going to be very difficult, and I have my sympathies with anyone who is in the room who is involved in these negotiations. I think I better wind up there. I've probably gone through my time already, Tricia, unless you want me to add a
Well,
bit.
this is important.
Well, if we do have the treaty that the government has been talking about between the UK and the EU, it will need to be ratified by all the 27 member states. As I say, that will be difficult within the 2 years specified in Article 50. There may be as many as, I've said 900 there, but it could be a few hundred less, but nonetheless, a huge number of agreements required to cover all the desired justice and home affairs instruments that are currently in place. And I've mentioned half a dozen during the course of a very quick presentation, but you will know that there are many, many others relating to road traffic, relating to mutual recognition of asset restraint and confiscation orders, etc., etc. It is a minefield, I suspect, and one that will take a long time to sort out. Thank you very much.
Okay, yeah, you're staying where you are.
I am staying where I am, yes. Thank you very much, and that was an excellent start, and it gives me a framework in my 10 minutes to provide a legal analysis of the options now, of the legal scenarios that we have in this period. First of all, I would like to stress what Mike also mentioned in his presentation, that this is not the first Brexit in the field of criminal justice cooperation. We had one in 2014 when the transitional provisions protocol of the Lisbon Treaty expired in November 2014, and the UK was asked to take it or leave it with regard to the old third pillar, which included measures such as the European arrest warrant. And the UK government decided to leave it and then topped back into these 35 measures, which, as Mike said, were the most important measures operationally in EU criminal law. So I urge you, if you have some time, to read Hansard at the time, when the current Prime Minister and then Home Secretary Theresa May went out of her way to persuade Parliament that it is existential for the UK to continue to be a member and party to these EU instruments, that if the UK is not a member of the European arrest warrant, to Europol, to Eurojust, and to the EU police and criminal justice databases, this would pose a very serious security threat to the country. And as Mike mentioned, the same considerations are equally valid today. So when we look at the possibilities for the UK after Brexit, we should have this in the back of our mind. There are various scenarios of what can happen now, and Mike, I think, hinted at those in his presentation. The first one is what the government wants, clearly, and the option is stated also in their paper on security, law enforcement and criminal justice future partnership paper that they published in the autumn of last year, which is a comprehensive security agreement with the European Union, so an EU-UK agreement on security. This is quite an ambitious proposal, and it is ambitious because it also covers aspects which are quite disparate within the current acquis. And the European arrest warrant and the European investigation order are one thing. These are measures envisaging cross-border cooperation, if you like. But then there are all the other measures on EU databases and access to them, like the Schengen Information System, the PRUM DNA database, which have a different logic to them. And the level of compliance, I think, with EU law may be a bit higher on these occasions. So the first scenario, the best case scenario, would be an EU-UK agreement covering everything. I'm not sure whether, even if there is an EU-UK agreement, it could be comprehensive enough to cover all the EU criminal justice acquis. You might perhaps have agreements on, on extradition, on evidence, and so on. We will see. The second scenario is the bilateral scenario. So the UK goes ahead and concludes bilateral agreements with the various EU member states. There are two problems with that. I mean, first of all, I think practitioners will probably tell you that this is hugely cumbersome. There are 27 member states, which will be prioritized in a sense, and agreements on what? You will not have an agreement on all the EU criminal justice acquis, one agreement with France, for example. You have again to unpick, and you have an agreement on extradition, an agreement on MLA, and so on and so forth. So this is a very, very difficult and cumbersome task, and moreover, it results into a patchwork in a sense, and something that is not mentioned also in this context is because we have EU law on all these matters. Even in the case of a bilateral agreement, EU member states, in the relations with the UK, will also have to comply with EU law, because the European arrest warrant now means that extradition is a matter of also EU competence, and member states in their external relations are obliged not to jeopardize the objectives of EU law. So France, for example, in extradition agreement with the United Kingdom, would also have to respect, albeit indirectly, EU law. So EU law will still have a say even in the bilateral relations. The third scenario is to fall back to Council of Europe, and again, I think our practitioners, and Mike was very clear and vocal about this. This brings you back to a different era. I mean, if you look at the current EU instruments on mutual recognition, they establish a qualitatively different level of cooperation. The European arrest warrant, the rule in the European arrest warrant is that warrant should be executed within 30 days. The process has been judicialized, so the executive is not involved, and a system has been created where collaboration takes place relatively smoothly. The European Investigation Order, which is a post-Lisbon directive, establishes a similar system with regard to the exchange of evidence in criminal proceedings, which is a hugely important matter operationally. And what is important for the European Investigation Order is that it replaces, as far as the relations between the EU member states, all the existing instruments of mutual legal assistance, both the Council of Europe Convention and the EU Mutual Legal Assistance Convention of 2000, which means that as far as the EU member states are concerned, all they apply is the European Investigation Order, which compels them to exchange evidence in a very speedy and almost automatic way. Now, can you imagine if the UK leaves this? I was in a team of external experts advising the Home Office when the negotiations on the European Investigation Order were taking place, and this was a post-Lisbon measure. And of course, the elephant in the room politically then was whether the UK should opt into this measure or not, because I think the government was understandably very skeptical of going out in the world and saying, oh, we will participate in this. And finally, I think common sense and reason and the views of practitioners prevailed. And again, Theresa May went to the House of Commons and said, we really need to be in this instrument, because if we're not, then we will be relegated to Z-list territory as far as judicial cooperation in criminal matters is concerned. I mean, can you imagine, and I'm sure Theresa has views on this, you know.
Tricia remembers pre-1990 when we were just that.
There you are.
Second-class citizens.
There you are. And now you have a highly integrated system of 27 member states. And I guess the question for a practitioner is, if I send a request for evidence, let's say to Germany, and I have requests from the other 27 member states, you know, which will be prioritized when they are bound by EU law with regard to their bilateral relations. So, you know, there are huge implications, I think, for day-to-day work if the UK is out of this. The fourth scenario, which relates to the EU centralized instruments such as the Schengen Information System database, is that the UK would be totally excluded, because if the Schengen Information System might mention that a number of countries are non-EU countries are members, and it's a possibility for the UK to be in, but these countries have to adopt in their domestic law every single amendment of the Schengen acquis. So Norway, in order to be part of Schengen, you know, every single Schengen building measure that we have within EU law, they have to replicate, and they have no choice in that, because it's such an integrated system that all the members need really to follow the rules. You want to make a comment on that?
Just
Yes.
to add in, I'm sure you're going to say it anyway, data protection.
That's the second part, yes. I have a lot on data protection. So these are the different scenarios. So what happens, and let's talk a bit about the Court of Justice, because this is also a topic which has been a bit misunderstood here. So first of all, if there is an EU-UK agreement, obviously the Court of Justice will play a role. I mean, the wording remains to be seen. Whether the EU will insist on having a legally binding role for the court within the agreement remains to be seen. Currently, there are agreements between the EU and third countries on extradition. So the EU has an agreement with Iceland and Norway, for example, on the European arrest warrant, where there is a clause saying that both the Court of Justice and the courts of these countries should review on a regular basis the respective case law and take into account of this case law. So this is a get-out clause, I think, in a sense, for the government on sovereignty grounds. But I'm not sure that the EU will agree on this clause as regards the more integrated parts of the acquis, as regards, again, the databases and the issue of data protection. On data, I think it is very important, because 70% of the EU criminal justice acquis has to do with some form of data exchange or protection. I don't know how many of you have followed yesterday's ruling in the Court of Appeal in a litigation launched by Tom Watson of the Labour Party and Privacy International against DRIPA, the former UK law on data retention and investigatory powers. which, as some of you may know, and as all of us, including the litigants, were saying, is contrary to EU law because it prescribes the indiscriminate bulk collection of personal data without the possibility of an independent review as regards of who and how this data is being accessed. And the Court of Appeal said yesterday, indeed, this is correct, and this piece of legislation was not compatible with EU data protection law. So currently, even with the UK being an EU member state, we're in a situation where the current domestic UK law is incompatible with EU law. And I think this is really the elephant in the room, because if the UK has any chance in being associated with any EU database, then it will be subject to an assessment by the European Commission that the UK provides an adequate level of data protection with domestic law. This is called the so-called adequacy assessment or equivalence. And I read the BBC this morning out of an unlikely source, ex-GCHQ head Robert Hannigan, who said that it was a bit naive to think being free from the ECJ would solve all our problems, and hinted that currently the UK, a lot of the UK data protection law is not really equivalent to the EU law. So this will not go away, and whether in any wording of any future arrangement, you will have an express binding force to the judgments of the European Court of Justice or not, in my view, on this occasion, is not as relevant. Because even if the Court of Justice is given a consultative role, the European Commission will not assess that the UK provides an adequate level of data protection. There is a very important judgment in the Court of Justice 2 years ago, the case of Schrems, which involved the compatibility of the EU-USA Safe Harbor Agreement with European data protection law. That had to do with a third country, which was the United States, and the court said unequivocally that this agreement cannot stand because US data protection law is not compatible with EU data protection law. So I think that we need to be realistic, and I think we need to be very careful about and very conscious about the impact of EU law on domestic law on the day after, regardless of the formal powers of the Court of Justice. Finally, a very final point, because a lot has been said about opt-ins and opt-outs and a la carte participation, and currently the UK enjoys this position because it can opt out of post-Lisbon measures if it doesn't want to, and currently we have, I think, a very problematic situation where the UK participates in the European arrest warrant but has not opted into a key measure on defense rights in the EU, which is the directive on the right to an access to a lawyer in criminal proceedings. And currently the UK can have its cake and eat it for political reasons. If there is Brexit and the UK wants really to have cooperation with the European Union on the European arrest warrant or on similar issues, it will have to apply the EU acquis as a whole. So in a paradoxical position, Brexit will bring higher compliance and more complete compliance of the UK with EU law than it does today. Thank you for your attention.
Right.
Would you like to stand? Yeah.
Yeah.
So we're going to drill down into a
We
couple
are
of
going to drill
things.
down. Only if I can make this work. Okay, well, we've now reached the stage of the evening where I know you'll be sharpening those razor questions that you've got saved up, but none of you will be thinking about drinks and the end of dry January or anything like that, will you? And therefore I know what you really want to do with me is to explore the principle of nabius in idem, because we all like some Latin, don't we, to get going with. What I'm going to do with you is I'm going to look really at one very specific area and look at it from a very practical viewpoint, in particular of advising individual or corporate clients what is likely to happen in an area which a lot of us are dealing with more and more, and that is achieving global corporate settlements. And I'm going to look then at the direction of travel in the EU about the acceptance of nabius in idem, which I know you all know is the principle of double jeopardy, how the UK has looked at this generally, and whether in fact, as in some other areas, we're actually going to be moving in opposite directions. So, not just to read it out, you all know what it is, Article 54 of the Convention, You don't keep getting done for the same offence within the EU. Fundamental principle goes back to 12th century here and is extremely important. Spelt out, and in particular, this concept of mutual trust in each other's systems, which of course, as we know, the Daily Mail are particularly fond of saying how much we really, really like how other countries do it, and set a good example, don't they? Not. So you can immediately see the tension coming in, saying, well, hang on, somebody's been dealt with in Spain. Does that mean they get off over here then? And attractive ways of looking at it there. But the philosophy within the EU is very, very strong. Mutual trust in criminal justice systems. Recognising criminal laws have to be enforced and respect should be paid when decisions are reached. So, let's see if we can move it forward on that. Yeah. What do we have in the UK? A slide you haven't got. We have a case called Fofana, F-O-F-A-N-A, which dealt with principles of double jeopardy, but in a very tight way, saying, well, yeah, but we really like to do it down the old lines of, is it the same or similar facts? Is it a criminal conviction? The judgment did accept that actually Schengen, Article 50, is incorporated and so has to be followed, but there's very few examples of that ever actually happening. So even before, if Brexit goes through, that happens, already the UK approach is fairly resistant. What, I know you're immediately saying, about Article 4, Protocol 7 to the ECHR? Doesn't that cover double jeopardy as well? No one should be liable to be tried or punished again in criminal proceedings under the jurisdiction of the same state. Yes, that does give you protection, but only within the same country. It is not transnational. The EU Article 50 protection actually is massive if it works, because you get protection throughout the EU, not just in that rather vertical way within a particular state. Let me see if we can move this on. Okay, now we come to the tension points. What's happening in Europe and what's likely to be happening here? The Advocate General has referred 3 particular cases to the European Court in connection with opinions by him about the direction of travel. And this related to a request from a preliminary ruling from the Supreme Court of Cassation in Italy, back to one of our old friends. If you bring criminal proceedings against, for example, a company or an individual, is it also fair, right, proportionate to hammer them under a market abuse regime as well? In other words, classic double penalty territory. And the Advocate General has no doubt about that at all. Article 50 does not permit double administrative and criminal punishment of the same unlawful conduct, here consisting of market abuse. Immediately, can we think how that could happen over here? Well, yes, of course we can. You can be done down at Southwark and the FCA can hammer you as well. So potentially we already have that level of double jeopardy built in, and at the time when we're already sensitive about it and maybe and are likely to be coming out of the EU, here is the EU going in absolutely the opposite direction, with the Advocate General who went back to what were called the Engel criteria for double jeopardy, which really means you look at the substance, not the form. If it's just called an administrative penalty, but actually, do you know what? It's really criminal in nature, it's got elements of punishment and deterrence and not merely compensation, we are going to take it as qualifying for double jeopardy. You can call it an administrative penalty and a sanction, but tell you what, we are treating it as criminal. And so that is a very substantial extra safeguard within that system. And, in his opinion, that may be relied on directly by an individual before a national court, which is obliged to give full effect to the right of nebis in idem. So that would mean, theoretically, if we apply this, where an administrative penalty actually is pretty much criminal sanction, that should trigger double jeopardy. Whether we'd allow that, I'm bound to say, I think is very much subject to question, and even less likely to happen once we come out of the EU. That brings us on to another topic we all love, particularly if I can get this to work. DPAs, and I know you talk of little else. So, big one, which we all struggle with, does a DPA qualify as being akin to a criminal penalty? After all, isn't it just a company being let off? Why shouldn't they be done for it again round the world? This, if you're advising corporates, is a really hot topic, and I will at the end come back, obviously, to Standard Bank briefly as well. So, France has had this going well. In June 2015, trial court in Paris says 4 French companies cannot be prosecuted. This is the oil for food corruption cases, because the corporate parents had entered into DPAs or NPAs in the USA. And actually, that has sufficient elements of finality and punishment that it would not be fair now for them to be tried in France. So fantastic, their stay out of jail, they can't be jailed, but stay out of fines free card seems to be working very, very well. It's not over yet because the prosecution have appealed against that and we're still waiting for a decision from the Court of Appeals. But for those advising corporates who want to know, does my DPA count around the world, this helps, or by admitting various conduct, actually have I made myself more vulnerable to prosecution round the world. Watch this space and we're going to see what happens. Now, Llama is a recent case, but on very, very different facts from white collar world, but it is indicative of how our Court of Appeal is likely to approach double jeopardy and takes a very, very limited, non-purposive in some ways approach, particularly where it looks like administrative penalties. Now, this is a very unattractive case because the defendant here was a colonel in the Nepalese army alleged to have carried out acts of torture, dealt with in a domestic court, a Nepalese court, simply by some compensation being paid and his promotion being put on hold for a year, which some might say was a trifle lenient for the internationally recognised crime of torture. Anyway, by a variety of ways through UN action, he ends up being charged as part of a UN mission with torture offence in the UK, which, as you know, is triable anywhere in the world, wherever it's committed. That part of the law really does work well. Well, slightly ambitiously in front of Lady Justice Hallett, he argues and says, well, tell you what, I know you charged me with the crime of torture, which after all only carries life imprisonment, but I've already been hammered at home. I wasn't allowed to be promoted for a year. It's absolutely outrageous. I've already had my administrative penalty. How can you possibly try me now? Anybody guess what the outcome of this one was? Yeah, not difficult, is it? But it's more what the court said. Of course, those facts were very, very different. I managed to do something silly with this, haven't I? Yeah, okay. Let's see if we can just go on.
Next.
Yes, next, but I've also managed to click something which was put up previous. Okay, we might just have to hear me talk about it if we can't move it forward. Anyone good with this? No? Okay, what the court said is, you'll just have to look at this with me at the moment, that the mere fact, for example, an expert witness had come forward and said, actually, it would count in Nepal for some sort of double jeopardy, didn't interest them at all, they weren't remotely interested in that, leave that alone, and it would not qualify as double jeopardy at all, it was purely civil rather than criminal, and they were not having any of it. You're going to come and do the IT bit and put it right for me. Thank you. Great. Brilliant. There we are. See if I can manage it this time without clicking something I shouldn't. Yep. The penalties there were civil rather than criminal in nature, not already been convicted, and therefore no problem whatsoever in trying him here. But I do want to look then at how the UK is approaching this in another context, and that is in the context of DPA and FCA settlement, and in particular in the Tesco case. Now, obviously, I'm very conscious of the fact that Tesco individuals are being tried at the moment, so I'm not commenting on that in any way at all. But then just look at the balancing out exercise and whether there is maybe some recognition of double jeopardy and a cumulative and totality approach. So, what happened? The DPA, very little is known about it because the individuals are being tried, but Tesco did enter into Tesco Stores Limited, a DPA, under which it was going to pay a fine, or has paid a fine, for £128 million. At the same time, they also settled with the FCA, which described quite clear market abuse conduct. So if we think back to the Advocate General's referral to the European Court, what he was saying there is, actually, prima facie, that's wrong. You shouldn't have this system where you can go under a criminal or criminal type penalty and have an administrative market abuse penalty at all. We do have both. Tesco could have been prosecuted, and they've entered into a DPA with definitely penal sanctions. But what's interesting is look at the global settlement they actually did achieve, and maybe some regard here was had to principles of totality and proportionality. Because I've taken this from the FCA press release, so it's all in the public domain. FCA decided, no, we're not going to fine you. What we're going to do, though, is enter a compensation package, which may amount to approximately 85 million. And as a result, the FCA does not propose to impose a financial penalty on either Tesco or Tesco PLC. So they were having regard here to an element of totality and proportionality, that you have been hit very hard under the DPA part. We will look at compensation. And so although the courts haven't backed this very much, in terms of advising clients, is there a possibility of achieving global settlement? I think that's probably quite encouraging. And it's the first time it's happened in that way, and I think is something which we can probably build on. Just a quick reminder, as you all know, in the US, they really don't care at all. There is absolutely no legal protection against further prosecution of a personal corporation already prosecuted outside the US. It's kind of, yeah, and so what? That said, and this is where I said I would go to and in fact end with, as you know, in Standard Bank, and Jane's Day and others in particular, achieved a very good result in that they did manage to get a global settlement for Standard Bank with careful negotiation with the DOJ. So, where does this end up? Ne bis in idem is a really important principle within the EU. The UK has always been reluctant to embrace it, being quite jealous about our own jurisdiction, and saying it's really got to be a criminal penalty, not an administrative one. And the directions of travel are in flat opposite directions. The EU, if it adopts the Advocate General's advice, will go much further and be very purposive and will definitely count administrative penalties. France, depending on what their Court of Appeals does, may say even US or UK DPAs might qualify, and I think we will take a much more restrictive view. That will be the legal position. Whether as a matter of pragmatics it's going to be possible to do deals in the way that Tesco did remains to be seen. But for all of us advising corporate clients as we do, we're going to have to say you're going to have to tread with extreme caution if you actually want to achieve that global settlement. So that concludes my part on it, and I'm happy to say with Tricia now we'll move into questions.
Beautiful timing. Thank you very much. Right, we've now got 20 minutes for questions, which is twice as much of each of our speakers now. And there's a microphone coming around. I'll start by taking, oh, there's one. Don't need to go off the wall.
Hello. I wondered if we could explore a little more the idea of arbitration agreements that would be aimed at replacing the CJEU jurisdiction when it comes to UK-EU cooperation. I confess I'm not familiar with them, and I'm interested to know what they look like, who would be the judges or arbitrators. Would they, for instance, be from EU states? These things might play badly in the UK. It's clearly, well, it sounds like it's the only possible solution to cooperation given Theresa May's red line.
I'm afraid neither Mike or I are in any kind of governmental organisation at the moment, so you might have
I don't know, unless anyone else will. I don't know of any arbitration arrangements apart from the so-called EFTA arrangements, European Free Trade Association arbitration system, which has been suggested on a number of occasions as a potential model that might possibly replace the ECJEU. Now, I don't know if that's a runner. whether the government would accept it, whether it would be acceptable to other EU member states. And again, this is something for negotiation. Apparently, and I've no experience of it, it works well. But I only get that from evidence that I've read that has been given to the House of Lords, who made some inquiries in that direction. I don't know if I can answer it.
There is a provision in the agreement between the European Union and Iceland and Norway on surrender, which aims to apply the European arrest warrant, to Iceland and Norway. Article 36, there is a provision on dispute settlement, which provides for a dispute settlement mechanism, which is a meeting of representatives by these countries and by the governments of the EU. So there is a precedent, I think, on European arrest warrants. It hasn't really been used in practice, but it is in the treaty when there is a query on the interpretation or the application of the agreement. So, but that's quite a governmental dispute settlement mechanism, so it's not really a judicial dispute settlement mechanism. So it is not really something, I think, that will probably apply towards a comprehensive UK-EU agreement on this. And of course, politically, all the governments of the EU member states are represented there.
So that's the best we can do, I'm afraid, with that one. I'm looking. I must say, I am very worried about what Mike was talking about, which is the collapse of all the arrangements that we have taken years to. And the UK has been in the forefront of these arrangements, quite frankly, the things that have come out of the original framework decisions and that have ameliorated the arrangements for extradition, for the gathering of evidence, for the exchanging of intelligence, and for the acquisition of even public records. I mean, we used to have to send the fee in specie for a search on not a central criminal records office, because in places like Poland they didn't have one when I was young. You had to send to the policeman the fee for going to the court of the town where the man was convicted to literally look at the record. I mean, I go back to the days of bankers' books, as does Colin, but it's not so far away. It's within my lifetime, my working lifetime, and things were so difficult you can't conceive when we didn't even belong to the Council of Europe Treaty, and sat there on the outside, still sending letters of request, in French and English with the red ribbon hanging off them via the diplomatic bag, where they didn't know what to do with them. This was very grotty. They didn't like doing criminal work at all. So someone's got to get a grip with this, or we will fall down a big black hole. Yes.
I assume that we're leaving the common foreign security policy as well, so from a sanctions perspective, I wondered if there'd been much consideration around the extent to which that will present challenges to aligning sanctions frameworks, or are we likely to see greater divergence which will push those issues into the private sector, who then have to kind of deal with investigations, etc., etc.?
I don't think we're going to want to drop behind on sanctions so much. My own view is I think we will carry on enforcing them. At the moment where they're brought in, we then bring them into domestic legislation straight away. I think unless we want to be seen as being just a refuge for anybody who wants to do bad things, I think we're likely to conform with them. And I think particularly some of our other legislation in the Criminal Finances Act, both do the unexplained wealth orders and failing to prevent tax offences, tax facilitation, makes me think that we will want to stay in line with that. Otherwise, we are really going to be seen as just the refuge country for those who behave very badly.
Just to quickly come back in, it's my understanding that a lot of the conversation at an EU level around sanctions, say the Russian sectoral sanctions, is kind of advocated from a UK position rather than us falling behind. Do you see potentially the EU falling behind and therefore divergence coming from that perspective?
It could do. I think there will still remain there a lot of common ground. And I think the way we've enacted the Criminal Finances Act, if it's used, including parts of Magnitsky Clause legislation, could be very effective. And that is an area where there probably could still be common cause.
Mike, I don't know what you think about that.
really, no, I've not had much to do with sanctions. I think there is a danger of separation, but there is, my limited experience is there's the UK and the EU on this have been on one mind, and nobody wants to fall behind on a commitment that has been made to put sanctions in place against a particular individual or jurisdiction.
One that back, and then this one.
Len Hawkes, I'm from Flynn in Brussels. I wanted to come back to this thing about adequacy and equivalence and the exchange of information a little bit. We also had mention a couple of times of the European Convention on Human Rights. Of course, the legislation about data protection is based on Article 8 of the European Convention on Human Rights. We've also heard criticisms of that convention. So, on the one hand, you have ICO saying we are going to implement the rules on data protection in the UK, and we will have the same rules. And on the other hand, you have some fundamental criticisms of the underlying convention, and you also have the judgment that you referred to in the Court of Appeal yesterday. So, I mean, could you just try and square the circle a little bit more on that particular point?
Okay, thank you. There's not only the European Convention of Human Rights. Of course, there is also the Charter of Fundamental Rights, which is really essential, an essential benchmark, if you like, for EU law, where there's not one article but two articles on privacy. There is Article 7 and Article 8, which are on privacy and on data protection. And we see the Court of Justice coming and having a number of very strongly worded cases, starting with Digital Rights Ireland and recently the Watson and Tele2 case in December 2016, where it has interpreted European data protection law in conformity with the Charter and the ECHR and giving it a very, very broad application. So saying that you cannot have a bulk collection of data, you cannot collect data without a specific purpose, and you must have independent scrutiny. So I think that we should not underestimate, I think, the court's approach in this manner. And the court is sending a strong signal both, I think, to law enforcement authorities of EU member states, but also to third states. So I think that this is not going to go away. I think that British judges recognize that the UK law is contrary to EU law. The UK legislator has continued to legislate domestically in spite of the rulings of the Court of Justice. Already we have disobedience in the field of data because Digital Rights Ireland was a case about the data retention directive, saying that you cannot just retain mobile phone data by bulk. Yet then we have what we have in the UK, we have data, and now we have the current piece of legislation which is very similar. I think this is brushed under the carpet because of Brexit. I think if it was any other EU member state, the Commission would have instituted probably infringement proceedings on that. But I think now, really, what's the point? In a sense, is it worth it? And it would stoke up further, I think, probably anti-European feeling. So this is a field, I think, that is very, very important for the judges. And we really need to be aware of the powers of the European Commission as an executive can issue assessments of adequacy. In Schrems, the Court of Justice castigated the Commission, saying that when you assess the adequacy of US law, you were not careful enough. And how can you not take into account subsequent developments, including all the NSA surveillance scandals? And what the court said is that the assessment of the adequacy, and that's also important for the purpose of the UK, must be ongoing. It is not enough for the Commission to say, oh, I have this assessment in 2020, then in 2022 they need to check, has the UK changed its law for the worse? And so compliance with EU law must be ongoing if you're going to be part of the game. And I think that's not being appreciated in all this talk about arbitration mechanisms or agreements and so on. EU law will be here, I think, and will have a real effect. if you allow me a comment on Tricia's point also about the Polish prosecutions and all of that, you must not forget that a lot of what is happening today in EU law is largely based on technology. So, we have a European Criminal Records Information System. We have DNA exchanges under the platform of the Prüm treaties. The UK, and maybe one of you can instigate a freedom of information request, how much money has the UK spent in order to make the UK systems compatible with SIS2 and with the Prüm treaty? I mean, there's a very long study, I think, that the Home Office published on Prüm explaining this. How are you going to undo all of these things? Isn't this also a cost when we talk about the cost of Brexit? And how easy is it to disentangle a country from a technological system where it's already in? So there are massive practical financial issues in addition to the very, very complex legal issues.
One at the front.
First, just one thing in relation to the question about sanctions. There is also a future partnership paper on sanctions, and I read that, and from start to finish it is about keeping everything absolutely the same in full continuity. To my unsophisticated mind, that made me think, then what's the point of doing this? But I also have a question.
Surely not. You mean we could have all this anyway? Yeah, absolutely. Yeah.
And Michael, I have a question for you about DPAs, and DPAs in Nevis in Edom. Is there a tension when advising companies or when being a corporate between saying that, well, here we have this DPA, which is a final resolution, therefore we cannot be prosecuted elsewhere, but at the same time, as companies would want to do, this DPA is not a conviction, so therefore we are not subject to debarment from government contracts?
Yeah, that's one of the tensions. The other one arises is, in order to enter into your DPA or NPA, you have to make a confession, which you then say you won't go back on. And various companies have found themselves caught out with that around the world as well. Obviously, one of the big attractions is it does not generally trigger debarment. So that is one reason why they will certainly want to carry on doing that. On the sanctions point, that's absolutely right. For example, Isle of Man and Jersey adopt, although they're not members, they adopt the sanctions automatically through their own domestic legislation. So I think that will continue. But I mean, without obviously revealing my hand about what I might think about Brexit, we do seem to be getting in a position where we're saying, well, that's amazing, so we could still be in all this and still keep to it anyway. And then you begin to think, well, why are we? Yes, exactly. Yeah.
The lady in red. As the song goes.
So as we've followed, or I've followed the passage of the sanctions bill through the House of Lords and listened carefully to the Hansard debates, there's been an awful lot said about the creation of Henry VIII clauses and giving ministers massive powers. Lord Ahmed has advocated strongly for this in relation to sanctions because the commitment of the UK is one that's firmly within the remit of the executive, and in order to keep pace with EU and UN sanctions and to be able to implement these things practically overnight. The same kind of arguments didn't find favour in relation to the money laundering sections of the bill, and we've seen an amendment recently clawing back some of that. But I've noticed in relation to the withdrawal bill that there's been some, a recent report has suggested that similar consideration needs to be given to Henry VIII clauses within that bill. So I just wanted to ask the panel what your views are if we go forward with any of the suggestions. The treaty, the multilateral treaty, the bilateral treaty, it's all got to be implemented through secondary legislation, presumably. And do you see more and more of these Henry VIII clause and an extension of ministerial power in order to keep pace with the changing legislation in Europe?
I would just say quickly, I think it's difficult to see it operating in any other way. It would clog up Parliament enormously to have everything go through as primary legislation. I just don't think it's possible. There's so much to do, and I think that's something that's been generally completely misunderstood and underestimated from the very beginning.
I agree. I think we will go for conformity in a lot of those areas, not least because if you look at money laundering directives and other parts, we were very often the primary authors of this point, which was completely missed in the debate. that most of it actually came from us anyway. So I think there will be a desire to go for conformity. I think we're absolutely right on sanctions, where it's got to be done very quickly. Again, we will want conformity with UN, with US, and to be seen to be following that line. Yeah. But I agree entirely with Mike. I can't see how it can be done any other way.
No. I mean, the awful truth was when Tony Blair's government wanted to abolish the office of Lord Chancellor, those of you who remember, and his civil servants were presented with a list of what was not exhaustive, literally hundreds of thousands of acts and statutory instruments which depended upon the existence of a Lord Chancellor, whereupon they backed off. They invented a Ministry of Justice, but not abolishing the Lord Chancellor, which was the original intention. And this is another one of these things. The amount of legislation in which the EU is embedded, it's, at the very least got to be dealt with by secondary legislation. We might even have to invent tertiary legislation. Stick in a book and say.
I think they
Oh, sorry, that's a negative resolution anyway, isn't it? Stick in the book, surely not. Yes.
I think the key challenge is how to keep up with future EU legislation,
Yeah.
the reaction to that. And
How are we going to notice that it's being passed? Big share.
Thank you. So I'm with the FCA, and we've found with a lot of our investigations recently, Eurojust were completely indispensable. We really wouldn't have been able to get some stuff to trial without them. What would be the kind of practical effect of going to an observer status as opposed to sort of a member status? What would that sort of completely jam up the system?
No, I don't think it would. I think that if we come out of Eurojust, I think that the UK would want to maintain an observer desk there. Now, the Norwegians and the Swiss, I think, have people there on a permanent basis. The US has somebody who's based in Brussels, but I think spends 2 or 3 days a week at Eurojust. So the UK could negotiate that sort of arrangement. The difference would be that person, that observer, would not be able to vote, would not be able to be part of the management of the organisation, because the management board of the organisation is made up of each of the national representatives from each of the member states, and they have meetings twice, I think 3 times a week, about management issues, and the UK would no longer be part of any of that decision-making process, so it wouldn't be able to set strategies or priorities for the organisation. But from a casework perspective, I would hope that the UK would maintain 1 or even 2 people there to help facilitate the sort of help that you've had.
There is also one thing that we used to use in the days before we joined the European Community and the various instruments, and that's the Freemasonry of the profession. So it is up to the FCA to go out and reach out to other regulators and persuade them that having their own meetings twice a week might well develop priorities that they could then impress upon the other clubs that they belong to. I used to work for Customs and Excise, and I must confess customs officers worldwide were very good at cooperating, and cooperating fast, without the sniff of an instrument. They didn't need a law, they just did it. And we collected their cards so we knew which Luigi to ring up. But it was quite effective, and regulators can do that too. Oh yes, we did. You get someone into court, I didn't mind. My back was broad, I didn't buy yours.
But I mean, again, the point you're making there, that international cooperation, the investigation of global crime, is absolutely critical. And we're about to take a retrograde step, and what Mike is describing is, if we're really good and nice, we might just about be able to claw back to a little bit of what we already have. Which again, in terms of international investigation and settlement, is absolute madness.
Oh dear, this is going to end on a depressing. Can we have something forward with Europe or something?
We can always listen to President Macron.
It's Lindsay McNally from the CPS. It's more a couple of points about to support the
the relevance of Eurojust, really, who are really fundamental in cross-European cooperation, especially on economic crime. In terms of an observation status as a country, I'm just wondering to extent which that will affect our ability to go into a joint investigation team, because the JIT itself is really core tool for cross-agency cooperation, and also it dispenses with the MLA aspects. There's no need for its lifetime exchange of evidence. And at the moment, I think we're one of the biggest users of JIT across all the Eurojust member states, and so it's a valuable tool that we use. There's that point, and there was just other point about cost and timing. Because of the mutual recognition models of surrender and now the European investigation order, that now obviously puts a time marker for the UK to comply very quickly with letters of request, which is something that we didn't have before. And I think it's something that, as the EIO is bedding in, we'll see the positive results of how other member states want to deal with the UK in terms of exchanging evidence. But there's another point about mutual recognition tools, which is that once we are served with the mutual recognition order, we have very little scope to challenge it in our courts, which in terms of freezing assets, it's actually a cost saving. We don't actually have to use domestic powers to take away any of these orders, and I think for things like asset recovery and freezing confiscation funds, we're just then mutually recognising them with the country's court order. So that's an important point, I think, for the UK to consider when we're looking at the arrangements we're going to enter into.
Well, on JITs first of all, yes, excuse me. Yes, the UK has been involved in JITs from the very beginning. We're involved in the first one with the Dutch, which was the drug trafficking thing back in 2005, 2006, I think, which was extremely effective and resulted in, I think, 10 people being given scores of years imprisonment. In the future, I think the UK can become or be a part of JITs, but again, I think I mentioned in my presentation that we will not be funded for that. We will have to find the funding ourselves. And I suspect too that we will have to ensure that the arrangements are in place so that the MLA situation in JITs is reflected and is available to us. Whether that can be done or not, I don't know. Yes, I agree with you entirely on the arrest warrant and on the investigation order. The time limits are something that was just completely new when the EAW came into force in 2004, and the 30-90 day limits were just amazing. And the fact that many countries that we had never expected to get people surrendered from did surrender people within or very close to those limits was a complete amazement for a number of organisations, not just prosecutors but courts and police and indeed the media too. The EAO, I gather, is working in a similar way. It's putting huge pressure on us. And the other mutual recognition orders or arrangements which are in place, these are things we're going to lose unless we negotiate some side arrangement. And of course, mutual recognition is something that the UK actually invented, as it were, or suggested at the beginning. Jack Straw, I think, at Tampere suggested it, or just before then, that there could be some sort of arrangement whereby courts within the EU would have their orders recognised for certain instruments, and it's grown from that, really. There are now many scores of arrangements in place, including the two that you've mentioned, and of course asset restraint and confiscation. It makes life so much easier.
Well, we've come to the witching hour of 7 o'clock, and it only remains for me to thank James Day for hosting this and for organising these excellent speakers, myself not included. And I'm sure you'd like to show your appreciation to the speakers and indeed James.